Section 1441A of Title 28 provides that, quote, any civil action brought in a state court of which the district courts of the United States have original jurisdiction may be removed by the defendant, unquote, to federal court. Under Section 1331, a federal court has original jurisdiction over federal questions. In pleading a lawsuit, does a complaint's passing reference to federal law in connection with what are otherwise state law claims bestow federal question jurisdiction under Section 1331? The United States Court of Appeals for the Fifth Circuit addressed this issue in Avitts v. Amoco Production Company. W.H. Avitts and several other owners of surface and royalty interests in real property in Texas filed a lawsuit in Texas state court for money damages based on injuries to their property allegedly caused by Amoco and other energy companies' oil and gas operations. The complaint alleged state law claims for nuisance, trespass, negligence, and breach of contract. The plaintiff's complaint made a single passing reference that the injury to their property was, quote, in violation of not only state law, but also federal law, unquote. However, no federal statute or other federal law provision was cited in the original complaint or any amended complaint filed thereafter. Nevertheless, despite the lack of complete diversity among the parties, Amoco and the other defendants removed the case to federal district court. In a subsequent filing, a proposed pretrial order, the plaintiffs made a brief reference to federal environmental statutes as the basis for calculating damages. However, the underlying claims against the defendants in the complaint were all based on state law. The district court ruled in favor of the plaintiffs, entering a preliminary injunction ordering Amoco and the other defendants to pay for an environmental study to determine the extent of pollution that they'd caused and awarding interim attorney's fees to the plaintiffs. Amoco and the other defendants appealed to the United States Court of Appeals for the Fifth Circuit.